Hello, welcome everyone, and welcome to our next lecture. This one is called Using the Law Effectively to Help Animals, and it is going to be hosted by Edie Bowles. She's a co-founder of Advocates for Animals at Advocates for Animals. She's a solicitor specializing in animal protection law. She has advised many animal protection organizations and individuals on a wide range of issues, including all aspects of the Animal Welfare Act and regulations made under it. She is a trustee of the Human League and a former trustee of the UK Centre for Animal Law, where she set up and managed a nationwide student group. She often speaks on animal protection issues and has done so in the UK Parliament, the French Senate, and the East African Legislative Assembly. Edie, welcome. We love to have you, and the floor is yours.
Thank you so much, and thank you for that kind introduction. So as mentioned, hi everyone, thank you so much for tuning in. My name's Edie and I'm a co-founder and a solicitor at Advocates for Animals. I'm really grateful to be here today, and especially I'm appreciative that everyone has tuned in on a Sunday. So first of all, who are we? Well, we're the leading experts in animal law in the UK and the only animal protection law firm in the UK. We launched in March 2019 after years of recognising that the law was incredibly underutilised in this area. We've had an incredibly positive start working with animal groups, activists and individuals on a wide variety of legal areas, and have helped enforce and further the laws that exist to protect animals. Now, aside from using the legal tools, there are many other benefits of having an animal law firm. So I just want to run through what some of those benefits are. So first of all, by having an animal law firm, you help professionalise not just the movement by adding to, already the whole range of professions out there, whether that be data scientists, lobbyists, food scientists. You not only add to that collection of professional skills, you also professionalise animal law itself, because prior to Advocates for Animals, animal law was predominantly a volunteer / pro bono led practice area, and still is in many countries. But it's only by establishing animal law as a professional area of law that animals can start to get their legal protections adequately enforced. This would be the case in any area of law that affects humans. So with humans, it's professional and specialist lawyers that you would encounter across the board. So, from property, family, criminal, human rights, commercial, etc. Each of these legal disciplines will have their own set of knowledge and skill set. So it's an injustice in itself that for so long, animals have not had their legal protections covered in the same way. Another benefit of having an animal law firm is that it normalises animal law. So there's an abundance of animal law out there. It's often not adequate, but it is there. The problem, however, is that the law is not being enforced. So if these laws exist on paper but are not being enforced, can they even be called laws? So again, professional animal lawyers are needed to normalise the application of animal law and send out the message that animal legal protections do matter. Another benefit of having an animal law firm is that it creates the infrastructure. So by creating a legal practice, it means building an infrastructure for continuous and expert services that can support the animal movement in years to come. One of the things that we keep hearing from our clients is how having an expert law firm on site to respond quickly and decisively has really helped inform the decisions and help direct key campaigns. It's also, by having the infrastructure of an animal law firm, it's also movement building, because more and more law students are interested in practicing in animal law, but without a law firm to house them, it'd be very difficult for them to practice in this area. It's not easy to set up an animal law firm. You need insurance, you need to meet certain regulatory requirements, and it's not cheap. It's actually very expensive. So by us already kind of paving the way here, we're hoping to help support the movement in that way as well. And lastly, an animal law firm helps create knowledge. Having a professional area of animal law means that time and expertise are made available to focus solely on the task of upholding animal legal protections, which in turn means an unparalleled depth of knowledge is being accumulated. So our vision at Advocates for Animals is to live in a world where animals are protected by philosophically consistent laws, which are regulated and enforced effectively. So as I've mentioned, we occupy a rather unique space as being the only animal protection law firm in the UK. So whilst naturally, once we take on instructions from a client, we have an overriding obligation to protect their best interests, we won't take on any case that comes our way. In fact, before we take on any case, any query, we ask ourselves two questions. First of all, we ask, do we have the capacity to take on this case? We're a very small team, and so we need to make sure that our resources are being used effectively. So that's the first question. The second question we'll ask ourselves is this an animal protection issue? So we've interpreted that, there's no defined term, but we've interpreted that not only as enforcing the laws that exist to protect animals, but we've also interpreted that as being the furtherance in some way of helping kind of campaigning organisations so they can fulfil their objectives. So we help support them with other legal issues so they can fulfil their missions. So I'm now going to run through some of the tools that we use to help our clients. And these are judicial review, freedom of information, undercover investigations, and prosecutions. Oh, sorry, I think I went too far. There we go. So judicial review. So first of all, let me apologise. Whilst this is, of course, UK, England and Wales centric, because obviously that's where I'm based and that's where I'm qualified, many of the tools that I'm running through, I imagine in many of your jurisdictions, you'll have similar tools available to you. So judicial review is part of constitutional law, and it essentially enables people to challenge the exercise of power by a public body. So a public body needs to act within the law and also needs to act within the powers granted to it under the law. So if a person feels that a public body has acted unlawfully or outside of their powers, they can apply to the High Court to decide whether the High Court also agrees that the public body has acted unlawfully. Now, for animal protection, the potential for a judicial review is vast. It really is the big guns of animal protection law. And that's because public bodies have a huge range of powers when it comes to upholding animal legal protections. So, for example, it's a public body that would grant the planning permission, let's say, for a farm. It's a public body that would inspect the premises where farm animals are. It's a public body that will license certain things. And generally, it's public bodies that will enforce the law. So therefore, if you feel that these public bodies are not fulfilling their duties properly, you can apply to the High Court. So as a firm or as individuals prior to Advocates for Animals, we've been involved in many judicial reviews, including a whole range of issues from farm, laboratory, wildlife, companion. We've been involved in considering judicial reviews across the board. We're also currently reviewing some at the moment, which I'm not at liberty to talk about today due to client confidentiality. But like I said, it really is one of the fundamental legal tools available. So just more generally to help you kind of conceptualize what this means, some of the actions that are currently being considered that I can talk about. Well, firstly, there's a huge problem with enforcement when it comes to farmed animal welfare law. So there's many responsible regulators in the United Kingdom when it comes to farm welfare law. So there's DEFRA, they're the main public body, but there's also the Food Standard Agency. They're the ones that do welfare checks in slaughterhouses, and also the local authorities throughout all the different regions of the United Kingdom also have some duties when it comes to enforcing farm welfare law. Now, they they have this huge range of powers. However, as mentioned, there's a huge problem with enforcement. In fact, an EU study found terrible under-enforcement of farm-related law. There's also problems with tail docking, inspection regimes, stunning, and effective penalties, all of which are clearly prescribed under the law, and all of which have been shown to be happening outside of the law on a systemic level. So because there's this huge problem of laws existing but them not being enforced, there is potential scope to challenge these public bodies and say, look, you have these duties, why are you not upholding them? However, part of the problem with doing that is that many of these regulators, they actually have powers, not duties. So that means that they have a discretion. So they may enforce, if they feel it's appropriate, but there's not necessarily the prescription of the fact that they must enforce. So like I said, it's a discretion. So this makes it kind of difficult because the court might feel that the public body has exercised their discretion properly. However, all is not lost because the court has said that these public bodies, even though they have discretion, they still must act properly. And if they're not exercising their discretion properly, they're still open to be challenged. And on top of that, if you could make the case that the laws are consistently not being applied, you may also be able to launch what's called a system challenge under judicial review, which is essentially the case that there is such wide illegality within the system that the whole thing needs to be changed. Another thing that we're currently looking at is we're looking into the salmon farming industry in Scotland and whether the Scottish government are acting lawfully or not. So the Scottish government are obviously the most responsible government when it comes to salmon farming in Scotland. As some of you might be aware, salmon farming in Scotland, Scotland is one of, I think it's the third largest salmon producer in the world. So it's a huge industry in Scotland. And what we found from having looked into this a little bit now is that there appears to be an unlawful legal framework. So for example, just a couple of examples, some of the treatments that are used to treat lice. So for those of you who don't know, lice are a real problem on salmon farms. They essentially eat the fish alive. It's terrible, and it happens because the fish are obviously, so tightly packed together. Well, some of the treatments that these farms use to try and get rid of the lice are also incredibly brutal, involve high suffering. And in fact, there's potentially the case to be made that they should not be being used under the law. And, for judicial review purposes, what you'd be looking at is challenging the Scottish government, saying that they're not enforcing the law properly by allowing them to be used. Other areas of potential unlawfulness with salmon farming is that we've recently discovered that welfare inspections are not taking place at fish slaughterhouses. So we're considering whether there's potential grounds there. And also more broadly, we're looking at whether the Scottish government has essentially allowed the industry to regulate itself without the legal power to do so. So there's some of the areas of judicial review that we're currently considering. So freedom of information is another really important tool. And again, I imagine in all of your countries, you'll have something similar. So essentially we all have, in England and Wales, and like I said, I imagine in your respective countries as well, we all have the right to information held by public bodies. And as mentioned previously, there are many public bodies involved in the animal legal framework, and more specifically, the farm legal framework. And so therefore, that means there's potentially a huge, a wealth of information out there that we can be getting hold of from public bodies. Now, they do have some exemptions they can rely on, such as health and safety, commercial information, that kind of thing. But the starting point is that if you put in a request, you are entitled to the information unless they can lawfully rely on one of the exemptions. Now, Information is, of course, the lifeblood of any campaigning organisation. Without information to influence the public and politicians, change cannot happen. So, this is particularly important in animal cases because so much of this goes on behind closed doors. So through requesting this information, you can help get a better understanding of the lives that animals are living. So this could be, asking for certain licenses. You could ask for inspection reports from the Food Standard Agency from slaughterhouses, or DEFRA if they're inspecting farms. All of this stuff is potentially available to a campaigning organisation under freedom of information. And on top of that, on top of just the simple fact that you can get hold of information, freedom of information also lets the public bodies know that they're being watched, which I think, it goes without saying that this will hopefully mean that the public bodies do not get complacent. I think it's kind of self-evident that if people know they're being watched, you'd hope that they would follow their responsibilities more. So some examples of some freedom of information requests we've been involved in recently. So as mentioned under the judicial review section, we've recently discovered that welfare inspections are not taking place at fish slaughterhouses. This was discovered through freedom of information requests. And we're also currently undertaking a huge freedom of information project looking into the enforcement. As mentioned, enforcement is a huge problem in this area, and so we really want to better understand. We want some data to support this. We hear it anecdotally all the time that someone's reported a welfare offence to the relevant public body and nothing's been done. So we're all getting this picture that there's a huge problem of enforcement, and on top of that there have been some reports that have supported this. But what we want to actually have now to support this premise, we want raw data to support it. So what we're doing is we're doing freedom of information requests throughout the country to all the relevant public bodies. So that includes the Food Standard Agency, DEFRA, the local authorities, all of which have responsibilities. So we're going to do we've started doing freedom of information requests, just asking them questions like how many inspections did they carry out, how many welfare offences did they find, what action was taken, just so we can fully understand the situation on the ground. So, sorry, I went past Undercover Investigations. So Undercover Investigations flows on very nicely from freedom of information, because, whilst freedom of information can help lift the lid and show some of what's going on, it's of course limited. You're only able to get hold of the information that the public body holds. And of course, the public body, at best, they're probably doing an annual inspection at best. So you really don't have a clear idea of how animals actually experience life. And so it's through an undercover investigation that you really get to see what that looks like on the ground. So of course, it goes without saying again that a picture speaks 1,000 words and footage even more. So undercover investigations are incredibly important for informing the public what goes on behind closed doors. So we help campaigning organisations navigate these. So, whilst they're incredibly beneficial, they do come with a whole range of legal risks, very complicated legal risks, certain criminal offences, trespass, confidential information, data protection. All of these are a risk when undertaking an undercover investigation. So we'll help identify those risks and we'll help mitigate them as well. So some of the undercover investigations that we've been involved in recently, we recently helped Animal Equality with their chicken and pig investigations. And we have helped, in recent months, we've helped Viva with an investigation into broiler farming. So prosecutions, again, is an incredibly useful tool. We've recently included prosecutions within our toolbox. So essentially a prosecution is the criminal action against someone who's broken the law. So we on the whole, prosecutions tend to be carried out again by public bodies, whether that be, through actions taken by the local authority, but also we have a central prosecutor called the Crown Prosecution Service. But on top of that, individuals also have the right to bring out a prosecution. Now, one of the reasons, so if someone came to us, perhaps following an undercover investigation where they've witnessed some criminal conduct, so some breaches of animal welfare law, if they come to us with that footage, it may be that a prosecution is the correct course of action. We would most likely advise that they go to the local authority, they report it to the local authority, or possibly even the RSPCA, largely because both those bodies, well, first of all, they'll have the resources to do any further investigation, but they'll also, quite frankly, they will fund the prosecution. So on the whole, that's the most advisable action. However, there may be reasons why the group or the individual don't want to do that, and instead they want to carry out the prosecution themselves. This could simply be that they want ownership over the prosecution, but it might also be that they've shown the footage or they've shown the photographs or the reports to the local authority or to the Crown Prosecution Service, and that those bodies haven't done anything. So in that scenario, it may be that the group or the individual want to take forward the prosecution instead. Now, prosecutions are incredibly topical because recently, so for those of you who don't know, the RSPCA in our country, they carry out the majority of prosecutions for animal crimes. And in fact, the RSPCA have a very high success rate in bringing these prosecutions. However, they've recently made the decision to hand over their prosecution role to a public prosecutor, the Crown Prosecution Service. Now, I'm in two minds about this. On the one hand, in an ideal world, this is correct because it speaks volumes that a charity was left to carry out the prosecutions when it comes to animal crimes for so long. You'd never find that with human crimes, that a charity was the main prosecutor for them. So it speaks volumes for how the government and respective public bodies view animal crimes, the fact that it's been left to the RSPCA. However, the reason I'm in two minds is because we do not live in an ideal world. And the reality is these public bodies, including the Crown Prosecution Service, are incredibly under-resourced. And on top of that, a parliamentary inquiry recently found that the Crown Prosecution Service did not have the correct expertise to take on animal prosecutions. So this means that there's potentially, going to be a huge gap where animal crimes are not being prosecuted. And so what you might find is that private players like campaigning groups or individuals fill that void, and we advocates for animals want to help them in any way we can. Now, I've run through the main legal tools, but I actually want to do a very quick overview of something quite novel that we're doing at Advocates for Animals that potentially has wide implications for all animals, including farm animals, under the law. And that's the property status of animals. So some of you might know that animals are treated as property under the law. Now, at Advocates for Animals, as I'm sure all of you feel as well, we're very uncomfortable with this property status. So what we've done is we've looked at ways to challenge this in any way we can. So just to quickly explain what this means. So under the law divides entities into two categories. On the one hand, you have legal persons, and they can have legal rights, they can own property, they can enter into agreements. The most obvious legal person being a human being, but also companies are deemed legal persons. And on the other side, so the other entity classified under law are legal things, and they cannot have rights, and they can be bought and sold and disposed of. Now, as mentioned, animals are considered property under the law, and as mentioned, Advocates for Animals is working in any way we can to change this. So as mentioned, as you saw earlier, Sylvia. So Sylvia is an example of one of these cases that we've taken on in an attempt to have this property status of animals considered by the courts. So just to explain Sylvie's case. So Sylvie is an old, anxious, blind rescue dog from Romania. She was rescued and was brought over to England and taken to a rescue charity that specialises in rehoming blind and partially sighted dogs. Now, the charity gave Sylvie to a fosterer, our client, to look after Sylvie while the charity found Sylvie's forever home. However, while Sylvie was at the charity, while Sylvie was in the care of the fosterer, in the care of our client, her anxiety started to subside as she got more and more comfortable. However, her health deteriorated through no fault of our client. You know, Sylvie is an old dog. And in fact, a vet said that if Sylvia is rehomed at this stage in her life, it'll be very detrimental to her welfare. She had a form of canine dementia. And so understandably, our client did not want to give Sylvie over for thinking of Sylvie's best interests. However, the rescue centre were not happy with this. They wanted to have control over how they rehomed Sylvie. We don't know why they took this position. They admitted that our client had looked after Sylvie. There weren't any concerns there, but they did want control over rehoming Sylvie. Now, our client refused to hand Sylvie back due to being concerned for Sylvie's welfare. And as a result of this, Sylvie became the object of a property dispute. Now, we got involved with this case for two reasons. One, we're animal protection lawyers and this, an animal was at risk, but we also got involved because we felt that this was a case where we could have a judge consider Sylvie's best interests and her welfare above her mere property status. So to bring this case, of course, just from the outset, let me say we can't wish up a case. We have to anchor our case in how the law actually is. As much as we'd like it to be different sometimes, we have to always anchor our case in the law. So the two arguments that we made, well, first of all, we made the case that there was an implied term in the foster agreement. So within the agreement, of course, our client had to look after Sylvie's interests. So we said, well, this would mean that there's an implied term within that agreement that says that our client cannot hand Sylvie back if it's not in her best interests. Unfortunately, we lost on this ground because, courts are very reluctant to read in implied terms into contracts. On the whole, a contract has to be an express term. You'll only get an implied term in a contract if it's so obvious that a reasonable person would assume that it made up part of the contract. And the judge felt that that wasn't the case with this implied term. So then that brought us on to our second point. So in the case that there was no implied term and Sylvie did then have to go back to the charity, to the rescue charity, we made the argument that the judge should use their discretion, use their judicial discretion to provide the charity with another remedy rather than having to transfer Sylvie back. So a judge has a choice when deciding what remedy is most appropriate to either order delivery up, so essentially the transfer of Sylvie, or to order some other remedy, such as cash compensation, essentially. And on this argument, the judge thankfully agreed with us, which is great, essentially. The judge felt that ordering our client to pay money for Sylvie was more than adequate to compensate the charity. So this is brilliant for not only our client and Sylvie. Our client was, of course, very happy to pay the sum, but it's also very useful. It's a very clear indication that judges are not comfortable with animals being treated as mere property. And in fact, when reaching the decision that cash was appropriate as a remedy, the judge did say that, and I think I've got the quote on the next slide, that essentially, Sylvie is unique, she has huge emotional value, she's essentially sentient. And so these were the reasons why the judge decided to rely on their discretion. So I believe that's all. Thank you so much for listening. Sorry, I rushed through the end because I'm aware of time.